Hi, welcome to another episode of Bringing the Law to Your Doorstep. So have you ever thought of starting a life in a new country, only to hit a wall of red tape? What if I told you that a rejection or refusal letter from the Home Office, specifically the UK Home Office, was not the end of a battle, but could literally be the beginning of a new fair fight? I get asked a lot of questions from different people. Why is the UK system so unforgiving? It seems that a plethora of the decisions that emanate from the UK Home Office are in the negative. And most of the decisions literally are unfair because the rejection letters are many and people literally don't know what to do. Yes, that is true. But what I also need you to understand and to know is that decisions are meant to be challenged. There is nothing like a decision carved in stone. Anytime a decision is given by an administrative body, including the Home Office, those decisions are liable to be challenged. And that is the work of legal representatives. That is why King's Court Law is in the picture. And that is why I see some beauty in pre-action protocols. Okay. So someone might literally ask that, what at all are pre-action protocols? Now, I want a perfect analogy to be able to explain this. Think of the dance before the storm. Okay. The literal steps you would have to take before the main battle. So in the context of immigration law, pre-action protocols outline the formal steps that you need to take as a lawyer or as an individual before you decide to file for what we call judicial review. So the Home Office, just like any other administrative body that can make mistakes, would have to have their decisions reviewed once a pre-action protocol is put in, what other lawyers will refer to as the PAP. So it's basically giving the Home Office the opportunity to reconsider their decision. And this is where the principles of public law come to light. So the questions that are usually asked are whether the decision was procedurally fair. That is the decision from the Home Office, whether the decision was procedurally fair, whether the decision was rational, and whether the decision was made taking into consideration the principles of natural justice. So the pre-action protocol must contain the details of the claimant or the details of the client in this particular regard, must contain the legal grounds on which the decision is to be challenged. And if there is any new information that needs clarification in there, all these things are prepared in a bundle or are prepared in the submission of a lawyer to be able to challenge some of these decisions for you. Now, the governing legislation for pre-action protocols in the United Kingdom is the Civil Procedure Rules of England and Wales, specifically the Practice Direction on Pre-action Conduct and the annexed pre-action protocol for judicial review. Okay, so this is just a note to the public to understand that anytime a decision is made from the Home Office, you shouldn't accept it hook, line, and sinker. No, that is the reason why legal representation is available to you. That is the reason why we are there as an organization, as King's Court Law, to make sure that we give the best of representation to our clients to be able to rectify some of these errors that are made in the decisions coming from the Home Office. So if any such decision has been given, do not be perplexed. Don't be worried. We are here to be able to guide you through the journey and to be able to get you the best possible results. Once again, this is King's Court Law, and we bring the law to your doorstep.